Okay. Yes.
Judges have come.
Yes, judges have come.
Sound come. Mute करो.
Gambata is
Tushar
Mute करो.
Only they can hear us.
unmuted. Then
They can hear us, but we can't hear them. You've told them we can't hear them. It's so unmuted.
Mr. Nariman, we can hear. Mr. Nariman, we can hear you. The solicitor is addressing. Can you hear what the solicitor is
oh,
addressing?
I'm so sorry. I'm so sorry, Manoj. Yeah. No, I can't hear what the solicitor is saying.
No,
I'll say that again.
Nariman, please have a seat. Please have your
I'm
seat.
obliged.
I'll just.
No, I'll be louder. You please don't get up.
उनको जा रहा है? What is the problem in the voice? It's going. Just see, Mr. Nariman, Mr. Solicitor.
Can you hear me now?
Yes, solicitor, I can hear you.
Yeah, Not the first contention. Kindly pardon a little repetition, not for my.
No, that's fine. Just
Yeah,
repeat what you said.
Lord, the question of law referred to a larger bench does not become infructuous because it is the question which is referred and not the inter se list between the parties. As I indicated, my lord, plaintiff and respondent both dies, but some question of CPC, some question of Partnership Act, if referred, my lord, would survive and may need your lordship's examination on a future date. Your lordships are, my lord, not examining right now. Your lordships would be examining whether to sit and devote time on this. There is a second ground and the last ground I can, my lord, persuade your lordships. My lord, kindly have a look, my lord, at a judgment reported in 2019, 11 SCC, page 1. Lord, this is the main Sabarimala judgment. The first 5 judge bench, 3/2 judgment.
This is the original judgment or the reference judgment?
The first judgment. Original judgment of 5 learned judges, my lord. 3 majority, 2 minority. Justice Deepak Mishra, my lord Justice Deepak Mishra presided. And my lord...
No, it is 4-1. 4-1.
I'm sorry, 4-1. I stand corrected.
That's what I asked, whether you are referring to the referring judgment.
No, my lord, it is 4-1. It is 4.
4:1, Justice Indu Malhotra dissenting. And
yes.
The next one is 3:2 on the issue of whether it requires to be referred to a larger.
Yes. My lord, that my lord Justice Chandrachud and Justice Nariman, my lord, dissent. I stand corrected. 4-1. I am reading the, my lord,
that opinion.
Majority judgment, my lord. If your lordships get the copy, my lord.
Judgment,
I am reading, my lord, opinion of my lord Justice Nariman.
Just 1 second, let them take out the book.
You put it in a compilation if your lordship feels it can provide.
Quoted or annexed?
Sir, we've made a compilation, we'll hand it over. Otherwise, they have
Is it annexed?
It's not annexed, but we've kept it ready. We can hand it over. Just give the compile.
If you have a compilation,
Give volume 1. Give only volume 1. There.
Look, this Daudi Vohra judgment was cited before the 5-judge bench in Sabarimala's first judgment.
My lord, this is at page 113 of the compilation. Sorry, sir, I'll just hand it to you.
Yeah, please. Just give me so that I can
I'll give
have
you.
a pagination tally. Now, kindly come to page 128 at para 163.
163.
Para 163.
163, my lords.
163. Yes.
Page 128.
He's reading this.
Oh, it's page 240.
It's page 240 of this compilation given by my learned friend. If your lordships are going by the running pages.
Yes, you got it.
I'll not read the whole, my lord, because it's not necessary for the present purpose. 163, my lords, get, my lord.
Yes.
In an illuminating concurring judgment, and Rajgopala Iyengar J upheld the act on the ground that excommunication is not so much a punishment but is really used as a measure of discipline for the maintenance of the integrity of Dawoodi Bohra community. It therefore violates the right to practice religion guaranteed under Article 25(1) and 26 in that it interferes with the right of the religious head, the Dai, to administer as trustee the property of the denomination so as to exclude excommunicated persons. The learned judge, however, drew a distinction between the two parts of Article 25(2)(b), stating that the expression social welfare and reform could not affect essential part of religious practices as follows. Lord, I may skip that part because that's not, Lord, for the today's purpose relevant. Kindly come to page 164. I'm sorry, para 164. As this view is the view of only one learned judge and it does not raise for decision in the present case, suffice it to say that this view will need to be tested in some future case for its validity. It is instructive to remember that Shirur Mutt specifically contained a sentence which stated that there is a further right given to the state by Article 25(2)(b), under which the state can legislate for social welfare and reform, even though by so doing it might interfere with religious practices. We therefore leave this part of Article 25(2)(b) to be focused and deliberated upon in some future case. So, my lord, this judgment, which, my lord, Dawoodi Bohra judgment is before your lordships, my lord, it is already held that this may need reconsideration. And therefore, also, my lord, if your lordship so considers, my lord, your lordships may have, this is, my lord, not a list inter se, and therefore, my lord, as an assistance, I can say, either your lordships, my lord, can, my lord, thereafter it went before 9 judge, I'll come to, the lordships may say that this can be reconsidered in the 9 judge bench, where, my lord, Sabarimala reference has ultimately gone, or your lordships may consider it, and your lordship's view would, my lord, be assisting the 9 honorable judges. My lord, now, my lord, I have prepared a note. If your lordships, I'm not reading the entire note. Mr. Sharma, you are audible. I don't mind Mr. Sharma being audible, but sometimes Mr. Nariman being audible, my lord, might. Lord, please, my lord, ignore the rest of the judgment. I'm not reading it. Ignore, my lord, not that they are irrelevant, but kindly come directly to page 13. Right side bottom is the pagination.
Yes.
Para in 18. Lord, only for the purpose of pointing out that by an order dated 10th February 2020 in Kantaru Raji Viru versus Indian Young Lawyers Association, the issues referred by 5 judges were reframed by the bench of 9 honorable judges. The said issues are quoted hereunder. My lord, so this question, my lord, 26.6. Lord, in fact, my lord, the questions are so generic that in answering every question, Dawoodi Bohra judgment will come for consideration. Now, of course, the list between the parties will not survive because of the new act which is enacted. And while appearing for the state, I have annexed, my lord, that act also. Page 39 is the act, my lord, by which the list between the parties will not survive. And that's, I think, broadly the agreement between the parties. But if your lordships, my lord, considers it proper, your lordships may examine this, or second option can be, your lordships may specifically say, this reference need not be answered because the judgment in Dawoodi Bohra and the dictum laid down can always be reconsidered before a 9 judge bench.
Mr. Bhatnagar had some caveats to it. According to his submission, even after the evolution of the relevant provision, he last time also flagged the issue that will the power of excommunication is being given up or not.
Well,
To which Mr. Nariman said he would not like to make any statement on that issue. All he is saying is that the offending provision stands obliterated from the statute. That is what Mr. Nariman can do. Therefore, to him, that aspect remains. So, question will be whether that aspect is required to be considered here. Is it something which is required to be referred along with the larger bench Sabrimala itself?
That can be the third option, my lord. I think better option.
That is also another option.
Yes, my lord. In my respectful submission, a better option.
Another reference, the other is to frame this issue in view of obliteration which has taken place, but then refer it to be heard along with the Sabrimala ban. I'm
That-
just debating, thinking aloud.
Correct. That in my submission, my lord, the issue between my learned friend and my learned friend are inter se dispute. I have nothing to say. But the third option, my lord, which your lordships, my lord, suggested, in my respectful submission, may be a better option.
Substantively, you are right. Substantively, the list doesn't survive. It's correct in terms of that. But still, some part of it, in view of the question he has flagged,
Otherwise, also question of law would
may
still
be
sir.
answered.
Question of law.
Question of law, suppose the question of law was only on the validity of this provision. Then the obliteration of that provision may not require answer at all because the substratum is gone. This is what we put to Mr. Bhatnagar, but he said, well, yes, substratum is gone, but some part of that substratum is left.
But my lord,
Therefore,
that provision was, my lord, dealt with in the context of Article 25(2)(b). So that interpretation of the judgment, my lord, dehors the parties then may perhaps survive.
no, I am saying only that if it was only that provision which was in question, maybe the question need not have been answered. Correct. So you are right that it doesn't get the obliteration of the provision doesn't take away the question, but it may not be required to be answered. But he seeks to raise something which is beyond merely the obliteration by pointing out the release last time I remember and saying that either it has to be answered, either they have to give a statement, or it has to be answered, or it has to be referred to to be heard along with Sabrimala.
precisely.
So among the three options, the option, Nariman had already ruled out the option of making any more statements than what is there. So that option is over. So I think the option before us is only this, that do we answer this question here? Is it appropriate to answer this question here? The limited issue which now remains, or whether we should refer it to
Give me the.
bench to be
Give me
heard
the-
with Sabrimala.
Lord, that may perhaps be, Lord, maybe a better option subject to your lordship's final call, because
Give me those three cases where repeal is done.
Sharma? Nariman's end. Mr. Sharma,
Mr. Sharma,
Yes.
Mr. Sharma,
can you hear me? Mr. Sharma, you will have to, what you mutually discuss is coming to us. I'm not, therefore it may not be.
I'm sorry, my lord, I'm sorry, yes.
It may not be advisable for your strategy to get your discussions this
I'm
side.
very sorry, yeah, I'm very
No,
sorry.
not at all. Just point out, this is part of technology issues which crop up. Yes.
No, what I'm saying is, even if we are required to reconsider it, it will end up in
Oh.
One more, my lord, just by way of an assistance. Lord, reconsideration of Dawoodi Bohra. Dawoodi Bohra is a learned 5-judge bench judgment. May perhaps not be possible, my lord, in this combination. Shirur Mutt is
That also issue arises whether, so just thinking aloud, what is happening is in either situation, they say the power of excommunication is something which has to be examined. One. So if we look at the questions of law we answered to which you read out, they are
broad,
comprehensive enough to possibly cover this issue.
they are broad, generic proposition.
But if they are not before the larger bench, then the problem may be in its nuance in which it is being urged here. It may not be possible. Or it may, let me say it may be possible that it may not be answered in those terms, in terms of this nuance. Correct. So therefore, both for the reasons that Dawoodi Bohra has filed judgment and the point they have raised and the reference made may require, thinking aloud, may require them to be there to raise this particular limited issue to be answered.
In the context of Article 25, which is a generic question frame.
Yes, yes. Yes, Mr. Bhattacharya.
My Lord, firstly, I think I really can't say that the questions that have been framed in a generic way and referred to 9 judges would have no bearing on this case, because after all, Article 25 and 26 surely arise in this case. And if your Lordship gives me the opportunity, I'll develop it on today or whenever as to how, my Lord, they arise in this case. Now, my Lord, what in this case has happened is that, as the learned solicitor pointed out, 3 judgments were delivered by the 5-judge bench. The majority of 3 said, my Lord, that this practice is an essential religious practice, number 1. Number 2, it does not fall within Article 25 2b, and therefore it is not, the Act itself, the 49 Act, is not protected as a social welfare reform legislation. That's what the majority said. The concurrence said that even if it falls within, it cannot possibly fall under 25(2) because no essential religious practice can come under 25(2)b because it will obliterate the religion itself. That is the concurrence. And the dissent, which I believe, certainly subsequently has found resonance, not in explicit terms, but certainly in terms of development of the law and further judgments of your Lordship, has touched upon various issues of excommunication and a very important issue of Article 17, whether untouchability is a limited a limited right or a much broader right, as the Constituent Assembly debates indicate. So these are the very important questions that arise in this case, but at the heart of it is the practice of excommunication. That is the substratum of the case. Now, my Lord, even if you look at the 2016 Act which has come in, which it was said makes this matter moot, there also it says that a community will not boycott somebody. But if I'm not part of the community after being excommunicated, that Act ex facie will not apply to me. So I'll show that provision. In fact, it's annexed. Please have a look at it. At the learned solicitor's note has it. So, my Lord, the issue, therefore, of excommunication certainly arises. If I may just invite your Lordship's attention to, my Lord, the Act which has been placed on record at, my Lord, page number, Annexure B at page 39. And at 41 is the provision which bars social boycott, just as the 49 Act had barred excommunication.
But Nagar, the difficulty would be this Act is not under challenge before us.
Correct. Absolutely, it's not before challenge.
So we cannot go into the validity of that Act per se.
I'm not inviting your Lordship. I'm only referring to my argument of the practice. I'm not saying that I'm in fact saying, I'm very sorry, not to interrupt your Lordship. What I'm saying, the Act does, the argument will be that the Act does not apply to a person who's excommunicated. Therefore, I can't challenge the Act. But in any case, this Act prohibits social boycott of people within the community. If the practice of excommunication is upheld, then I'm not part of the community, and therefore the Act does not apply to me. If, as I say, the practice is abhorrent to the Constitution, and certainly, my Lord, that's going to be my argument, and for your Lordship's consideration, then of course different considerations will follow.
Should we go on the hypothetical basis that Act will be challenged and it will be...
No, I'm not on the Act at all. Please keep the Act out of it is what I'm saying. I'm saying please only focus, and my focus is only on the practice. And what the 5-judge benches said. I also, as I said, my Lord, it cannot...
Do I understand you correctly?
Yes.
You are saying that you are not required to assail the provisions of the Act.
That's what I'm saying.
In terms of your reading of the Act.
Yes.
But there is an element of insistence of continuation of the excommunication practice,
yes,
by the head of the community,
my Lord,
which is, according to your submission, abhorrent to the Constitution provision.
This is precisely my submission. And just to add one line, and it is not a protected practice under 25 and 26.
And now, in a sense, the new Act doesn't permit it.
The new Act doesn't permit, according to me, the new Act would have no bearing on it. Because if the practice is upheld, then I'm anyway out. So, but as I said to your Lordship, I cannot possibly say that the generic questions that have found their way referred to 9 justices will have no bearing. After all, there's a question of constitutional morality.
But one option was to await that view and then take up this issue. But then honestly, my concern is only that it may deprive you of the opportunity of bringing this nuance. And suppose, as and when that question is answered, suppose this aspect is not answered, we will be back to square one.
We'll be back to the specific.
Then we will be debating whether this practice is there or not, and then coming to a conclusion whether again it requires to be referred to a larger bench
Yes,
because it's a 5 judges bench.
yes.
That's the issue which will arise.
You know, one other issue that I must flag now before your lordship, because I'm just assisting your lordship, is whether your lordships can directly refer it to 9. There, my lord, may I just cite one para from the reference order in this very case? Because we said it should be before 7 judges, but a 5-judge bench said, no, you first must go before a 5-judge bench, and only if they agree with your submission, at least prima facie, then it can go to 7. So the option, according to me, what this judgment says is,
That will be ultimately that's a call the Chief Justice can take.
that's exactly correct. That's what I was saying.
We will only say that the questions framed in the 9 judges bench, if we agree with you in that sense,
Yes,
would have a bearing on the question framed here.
right.
So therefore, the option is either to refer it to a larger bench or which may be 7 judges or 9 judges, depending on the chief's prerogative. But that the generic questions framed in the
9 judges.
Tribunal matter would have a bearing in a particular nuance in this case.
Except that my specific question is not referred also, as your lordship very rightly
That's
pointed
why I
out.
am saying, and in that nuance it is not referred.
Yes. And so, as my lord very
So,
rightly
okay,
said, it's very
visibility
possible
would
that
be
we'll be back to square one.
So therefore, we would have to frame that question in that nuance and say that this is the question according to you it needs to be answered.
That's right.
The single question now.
Single question, whichever way you know.
Only one thing, the option of referring to the 7-judge bench, 7 honorable judges, my lord, was available in the review also in Sabrimala, but the court chose to refer it to a 9-judge bench because Shirur Math is 7. So, and that also falls for consideration.
That's right.
That's why it went from 5 to 9.
My lord, may I also submit?
Just.
Which is tagged along. My lord, less in my case is present, my lord. Because, my lord, I was excommunicated on the ground that I had participated in, my lord, before remarriage of a person, of my sister-in-law, my lord. And then, my lord, I got excommunicated from a caste association. This caste association, my lord, is of 27 villages in the region of Kutch, my lord. So therefore, my lord, once I file a complaint under this act, summons were issued, but the Honorable High Court, my lord, quashed the summons on the ground that because in the Saifuddin judgment, the entire act has been held to be void. Therefore, those summons were quashed, my lord. So therefore, even under the new act, my lord, the process will not revive. That's all, my lord.
Is not allowed.
Just to add one thing, my lord, we don't say that the list doesn't survive in our case. According to us, list very much survive. Of course, subject to the question that your lordship.
No, there are two parts. Substantively, the list, Mr. Patanga, doesn't survive actually.
This is the excommunication practice.
No. But if the provision, one is the challenge to the provision. You are saying doesn't lay down the correct law. This provision should be.
Right.
The amendment provision takes away that offending. According to you, what is an offending provision is taken away. But you say that despite that offending provision being taken away, the list square, the practice of excommunication still subsists.
Yes, my point is only that the list for excommunication subsists. Yes, the act is gone in any case. So now.
Yes, Mr. Nariman, we would like to.
May it please your lordship, my lord, I'm very much obliged for this opportunity to address you, my lord. I would have really been delighted if I was there physically, but my lord, there are all sorts of constraints. Otherwise, I would have not.
We would also have liked you to be present here, but then
No, it's only because of your indulgence that you are, my lord, able
something
to,
is
give me an
better than
audience.
nothing.
My lord, the point that the learned solicitor has raised, my lord, is important. I'm not saying it's not important. The questions that have been framed are also important because they would have a bearing ultimately on something to be decided, in this case, affecting the Sayedna judgment. There's no doubt about it. It would be so. But the point only is, my lord, today you have a writ petition of 1986. between a petitioner, the state, which is now redundant because the state was to support the act, but the act is repealed, and a private individual. Now, my lord, a tenor of decisions have said that such a writ petition is not maintainable at all. Now, whether you decide it now, you decide it later, you decide it after 9 judges, but at some point of time, that decision will have to be done in a pending matter, because that is the only matter before you, containing a whole bundle of facts, a whole set of denials, lot of affidavits, which I'm not bothering you with. Therefore, my lord, the question certainly can be referred, but nothing survives today in this petition, and that's for your consideration. Because although the act is repealed, the question of my right to excommunicate and the challenge to that survives does not enable the present writ petitioner to move under 32. That's for your lordship's consideration. There are judgments of your lordships specifically saying between private parties there cannot be an enforcement of the writ. Now, that's one of the considerations, whether you take it up now, whether you take, I'm not at the moment trying to short circuit anything, but take it up now, take it up later, but that question does arise, and it will arise later. And there is one solution to this, perhaps, following what the solicitor says, namely, in the Sabrimala case, it was contended before one of the dissenting judges, my lord, Justice Chandrachud, just as Mr. Nariman dissented, Justice Chandrachud also dissented. And the justice, that the Saina case should also be referred. And his lordship said, if your lordship turns to the Sabrimala judgment at page 180, para 272, 2019, 11 SCC, if you have got it with you, my lord.
Para 272 you are mentioning?
I'm obliged, my lord, at 180. This is the other dissent of Honorable Justice Chandrachud. And this lordship says, my lord, after discussing it at the bottom, just before 273.
This is concurring,
The
not
decision
dissent.
in Saifuddin, he calls it Saifuddin, it's a Saidna case, is presently pending consideration before a larger bench. That is your lordship.
Yes.
Because this comes subsequent to the 5-judge bench judgment, my lord, which said that if you are convinced that the law laid down is wrong, then you refer it to Salam. Lavati's judgment. So, my lords, quite frankly, this was all considered by the judges. It's not as if it's only it happens to be the other dissenting judge refers to it.
But in this opinion, Mr. Nariman, Justice Chandrachud's view was the
You was just same as Justice Nariman.
So it was the majority view. In this one, it's the majority.
Yes.
Yes, it was the majority view, same as Justice Nariman and same as Chief Justice Deepak Mishra.
Concurring majority view.
This is the concurring majority view, 4:1, which went.
Absolutely correct. It's only Honorable Justice Indu Malhotra who took the dissenting view, which ultimately Justice Gogoi Malhotra thought was a correct view, and ultimately all those questions are arisen. So there is no doubt these questions, the questions as framed by the 9-judge bench, I can't get away from it. It requires to be considered, and it will possibly be considered in God's good time. But today, my lord, we are faced with this problem. There's no question of referring anything.
So Mr. Nariman, we would like to have your response to a view canvas that since that 9 judges judgment is awaited, instead of awaiting that, if on this practice of excommunication, a question is framed and also referred, the parties will have the opportunity to assist the 9 judges bench in respect of this particular nuance of the larger generic questions framed as the first 2 questions.
I don't think that would be a proper way of doing it, if your lordships don't mind. my
No,
saying so.
I'm seeking your assistance and opinion as to what you feel about it.
Yes, I'm very much obliged. No, this matter comes because of Justice Lahoti's judgment.
Yes.
Because they were, in Sabrimala, this was contended. And Justice Chandrachud said, no, this is now before a 5-judge bench, let them decide whatever they want to do. And your lordships are now deciding what to do. And my suggestion, my lord, following the suggestion I made, which I consider, my lord, quite reasonable of the solicitor, that apart from the lists, etc., that just let this, my lord, stand over till the decision in the 9-judge bench, because all those questions, this question has to arise. There's no question of now framing another question and referring it again,
Okay.
because that occasion doesn't arise.
And anything else? Anything else, Mr. Nariman?
I'm sorry.
I said anything else you would like to say? I think.
Yes, I'm sorry. I would like to only say this, that as early as possible, a 9-judge bench should determine those questions, because they are all pending. No one can, my lord, gainsay that the 9-judge bench has dissolved. It's not dissolved. The 5 of the judges have retired, etc., but that makes no difference. Then there is an order of the 9-judge bench framing questions. So either they have to be answered, or, my lord, something has to be done about it. Now, and I have no doubt that the answer to that question will certainly help this honorable bench to determine the correct view to be taken on excommunication. There's no doubt, because you just see the questions. They are all the questions 2 and 4.
Yes, they have large generic question, but Nariman, on the lighter side, this is not in my hands.
Actually, just to, the matter was, in fact, the 9-judge bench was listed for 1 week of continuous hearing in 2020 March.
Yeah, but then COVID intervened.
Otherwise, it was
It was
fixed.
only set for a day.
So, but unfortunately, because of that.
But initially that flu intervened. Swine flu intervened. 2 honorable judges comprising of the bench were infected.
Yes.
And thereafter, immediately COVID.
2 of us have gone through it. Yes.
Yeah, that's right. And then when we have never seen the light of day. But my lord, we would also like this question to be decided at the earliest. There's no doubt about it.
Understand.
Therefore, I suggest, my lord, that at the moment, if it's convenient, without raising any preliminary points, which I am not raising them at the moment. Let all of this be decided after the 9-judge bench formulates its answers to the questions. That's enough. Whether it decides the review in a one way or not, it makes no difference.
Okay. Thank
Just
you.
one, not just me, 2 minutes.
Just 1 second. I gave you a chance. Now, what do you want to say in supplement?
Lord, there is one issue or one question which even
About my learned friend, sorry, my lord, to interrupt. Sorry to interrupt you. My learned friend who's just arguing, he's not connected with the Dawoodi Bohras. It's another community from Gujarat.
That's a different community, my lord. I started with that. My lord, the moot question is that in this, can an individual, maybe head of any community, can he exercise sovereign powers of judiciary? My lord? Whether sovereignty would be the basic structure of constitution.
Sorry, I'm not getting it. How does sovereignty
My lord,
come into it in power of excommunication? The constitution doesn't permit us to excommunicate anybody, so there is no.
exactly, my lord. But
That's
my lord, sorry, my lord.
So therefore, see, ultimately the same thing. It's not. Let's not expand it to what you are saying. The simple issue is whether there can be an exercise of power of excommunication, and Mr. Bhatnagar said. That's all. And he seeks to test it on a constitutional provision. Now he says that frame this question and refer to a 9 judges bench. Mr. Nariman says no. Let us see the answers to the 9 judges bench and then take up this matter. That's the gap between the two on the submission.
May I just add to what?
Because
We'll hear you, don't worry. We have
because,
all the time, there's no difficulty.
No, I don't want to intrude.
because my lord,
Very short.
as far as in the Dawoodi Bohra case, as well as in my case, the excommunicator does not seek power from 25 and 26. They are seeking sovereignty, my lord, in Dawoodi Bohra case from Allah, And my lord, in my case, it is from canonical text, my lord, of the Hindu religion, my lord. So the point is, on one hand, there is a religious sovereignty coming from God, and on the other hand, my lords are sitting here, my lord, have exercising sovereignty under the constitution. So can there be, my lord, parallel courts? In fact, my lord, there was a judgment where, my lord, the issue of fatwa was considered by this honorable court, my lord, in the division bench. There, my lord, they said that it can, issue of the fatwa, the nature of fatwa can only be, my lord, recommendatory, a conciliatory exercise, but the
Cannot be a prohibitive exercise.
yes, my lord. It cannot. The list. Basically in this case they say that civil rights vis-a-vis 25-26, but civil rights has to be decided by a court of law. Those civil rights can't be decided by individual, my lord.
Thank you. Yes.
Just a moment, my lord. The reason why the cause suggested by Mr. Nariman may be the correct one, there's another reason. Your lordships recall Justice Lahoti's judgment sitting in Constitution bench is that your lordships will decide to refer to a larger bench only if your lordships are first satisfied that the law decided in the 1962 judgment was not correct. Now, the very argument of my learned friends that these issues arise before the 9-judge bench itself shows that as of now, there is no law decided of a larger bench that is contrary to the 1962 judgment. Today, the 1962 judgment we are in a position to show is still good law. It may be that because of the width of the issues before the Sabrimala bench, some decision may be taken before that bench, which has a bearing ultimately.
What Mr. Nariman said to
Correct.
that extent is obvious that it is bound to have an effect.
Yes, that's right.
It can't be that it will not have any
It's a
effect.
wider question.
Nariman is right in this question because the
Absolutely.
question is very generic and wide in its terms. So I don't think we can say that it will have no impact.
No, it will.
Therefore,
No, that's right.
The question is only whether to withhold the matter, as Mr. Nariman says, or refer it to the same.
No, I put it wrongly, my lord. What I meant was that the decision in Sabrimala may end up showing that the law decided in 62 was correct also.
You have not put it wrongly and we've understood it also.
Correct, correct. No, therefore, today the issue is whether this writ petition should be referred to the 9 judges bench. But I don't believe so for several reasons which we have said.
Writ petition as a whole cannot be referred.
Correct.
Certainly cannot be.
It's only the question.
Only question would be whether this question, his argument seems to be, which I endeavored to rephrase, was that let me have a chance before the 9 judges bench to address on this limited issue, because that may have a direct impact on what view is taken in this.
And
That's
my lord, he can always seek intervention before the 9 judges. Because otherwise, every such matter will go before them, or they'll have a pile of matters.
Understand. And,
That is the short
the
point.
bulkiness of the problem which crops up.
Can I just
Yeah,
respond?
Mr. Lordships, only for a few minutes.
You are for whom, Mr. Tripathi?
I'm not supporting what Mr. Nariman is saying. I'm also supporting what my friend is saying. I won't.
You're also supporting Mr. Bhatnagar, all three.
Sorry, my lord.
on different causes, yes. For different causes, yes, my lord. Now, my lord, I make the respectful submission. I'll be very brief. Point number one, my lord, that the issue is there before the 9-judge bench. All the parties here, there are some interveners, etc., and the writ petitioner have all been included, my lord, there. So they are present before the 9-judge bench. So it is not that their voices are not going to be heard. That's very important. That's point number one. Point number two, my lord, is that this present writ petition is the writ petition of 1986. Amendment is sought in 2016. The Act comes in 2017. The Act is brought in the written submissions filed in 2022. So this is the 2017 Act is not the subject matter really of this.
That, Mr. Tripathi, if you saw, we put my brother said to him. He says, I'm not challenging the new provision, the new Act.
That's right. But Malad, the point is that
there's no issue on that.
Lord, I heard that. But Malad, therefore, the position as it stands today is that the Act has gone. It has been repealed. The repeal has not been challenged by them. They have not even mentioned the new Act. But if whether I am captured by the new Act or not will have to be an adjudication done in my respectful submission in an appropriate proceeding by the High Court for this reason, my lord, that I have, supposing there's an adverse view, if it goes via the High Court, because there's a writ petition here, Because if it goes via the High Court, I still have the right, my lords, to come up before my lord. That was the point which was dealt with in the Antule case. That my lords, primary adjudication.
Party. You are right in some fundamental, but the fact that this 32 petition has awaited a decision from 1986
That is true, my lord.
also troubles us.
I see that. But my lords,
We are not blaming anybody for it, but
no, I quite see that. As part of my law, as being my lord's officer, absolutely. But
as
kindly
an
see.
institution, it troubles us.
No, I see that. Lordship is right. I'm at 1 minute and I'm really sorry for that. But please see this, from 86 till now, no early hearing ever moved. Nothing. They put in an 86 petition and my lords, keep it, my lords, it's as if it's a dump of biryani, pardon my expression. You just put it there and wait for it to simmer. Then 2016, they come up, my lord, with an amendment. 2017, the act has come, there is nothing. So, my lords, they are also not entirely not amiss. May I put it like this? Therefore, my respectful submission is, please refer this. And they are all of us will be there, my lords, we are all there in the 9-judge bench.
Somebody may enjoy the biryani, somebody may not.
Can I just respond?
Therefore,
to-
my lords,
That is Khanna. Okay, on the left. Yeah, they know that. They know that. Sunday, the place is not trying to.
the 1949 Act, which was struck down by a judgment, which act has been repealed. There is only one prayer, my lord, in the writ petition. And the prayer is that please declare that the judgment is wrong. Now, my lord, what is the impact of the judgment in the 2017 my lord's Act is not even being contended by them. That has to be decided at some stage. Therefore, this writ as it is filed, my lord, is completely non-maintainable.
After the amendment, what is the effect of the affairs?
That's right, my lord. So after the new act comes in, what is the effect of the judgment on the new act?
I'm saying you said 2016, they amended the petition.
Yes, my lord, in amendment, they added some more, my lords, description and, my lords, contentions relating to what is meant by excommunication and barat. And, my lords, that is the sum total of the amendment.
In the relief, there is no.
My lords, please see the relief at, my lords, page 59.
The amendment is not yet allowed. It's only an act.
Amendment is not, my friend is right, amendment is not even allowed.
Amendment was not allowed because the matter never came up.
No, my
after
lord,
that
they
before
never
five judges.
moved, they
No,
never,
Mr. Tripathi, you can't say that they never moved.
they never
Not
moved.
something I'm willing to accept.
My lord, they never
I want
mentioned
to give
the
a
matter.
short rejoinder to all these. Just give it to me.
Yeah, let me just finish.
Yes, let it be.
My lords, then
That's not something which frankly appeals. We keep the matter pending. We can't penalize other people for keeping the matter.
wait a minute. Well, may I make the second submission? No? The prayer, my lord, in the writ, because one of the writ has to be taken as a whole.
I'm saying what is the prayer that we've seen? I'm saying what is
Well-
the prayer made in the amendment? I'm asking.
Amendment prayer is, my lord, petitioner, my lord, the grounds are given as to what is the effect of Bharat and excommunication
What is the
vis-a-vis.
prayer? Bhati, what is the prayer?
Yes, the prayer is give the prayer. Declare the practice of Bharat excommunication for reasons connected and unconnected with observance of religious tenets to be
So
unconstitutional.
they have raised it in the amendment. You are right that amendment has technically not been allowed, but
My lord, they have not dealt with it in the context of 2017 Act.
that you are right.
Therefore, my lord, that is the issue today. Does the 2007, what is the effect of this excommunication in the 2017 Act? That issue is not at large before my lord.
Okay.
And lastly, my lord, one last submission, which my lord, that I also mentioned, and I will respectfully say that normally your lordships will be persuaded to refer a matter even to 9 judges if my lord is prima facie satisfied that the judgment in question requires reconsideration. But all I'm saying is, please await the judgment of 9 judges.
That's
And
the same prayer. You are joining the prayer of Mr.
That-
Nariman.
Nariman.
Because
Can
my
I
friend
just-
very adroitly says, please don't examine this and please refer it per sub silence to a larger bench. That my friend can't say. He has to show that the judgment
Yes,
is
I'm showing that.
patently wrong, it requires reconsideration.
I'm showing that. Now, my lord, if your lordship would kindly see, when the 2005 5-judge bench headed by Chief Justice Lahoti took up the matter, there was no reference to a 9-judge bench on certain framed questions pending then as it is today. In fact, there was no reference pending at all on any question. Today, we have at least some generic questions referred. So there is a complete sea change between what happened in 2005 and what is the position today. That's point number 1. Point number 2, my lord, so far as this judgment and its correctness, etc., is concerned, 2 judges in the majority in Sabrimala, 2 judgments, I should say, in the majority in Sabrimala, have expressly referred to what was held in this case, what the issues were in this case, and how it is pending consideration. So, at least 2 judgments, 2 honorable judges, that is to say, Justice Nariman and Justice Chandrachud, took the view that these issues are pending and required to be decided. Now, my lord, in my case, the specific issue of excommunication will not be dealt with by 9 judges unless, my lord, the question is framed. Because otherwise, we will only be looking at questions whether Shirur Mat was rightly decided on essential religious practice, whether 26B is subject to 25(2)B, etc., etc. These will be the questions. What is the scope of constitutional morality? Now, here the other questions that arise, which are specific to this case, if, my lord, your lordships are pleased to refer the excommunication practices constitutionality, would also be Article 17, which the dissent of Justice Sinha has clearly dealt with. Whether Article 17 would apply across the board or it would only be a caste-based disability or ability. So that is the reason why, my lords, I am requesting your lordship, beseeching your lordship, that this particular just one issue, this petition can be kept pending and disposed of at a subsequent date is no problem. But this one particular issue on whether the practice of Bharat or excommunication is constitutional or not is something that your lordship would consider referring.
So, but I have one question. Other than that, what is in this matter?
But that is the whole issue, my lord.
When you said keep the other issues pending in this,
No.
according to you, this is the only issue.
The only issue which and the consequences of this practice which we also raised, but the main issue is this one, your lordship. Absolutely right.
Yes, sir.
It's all on this side.
On the takedown, on the main petition and the application amendment. The conspectus of the arguments in court, orders result. We'll examine it in.
I'm deeply.
Please, Your Lordship. Immensely grateful.
Grateful to
Very grateful.
Thank you, Mr. Nariman.
Thank you, my lord. Your lordships are reserving orders.
We are reserving orders.
I am very much obliged. Lordship, please.
Oh, sorry. Sorry.
So attorney, we can welcome you on your first appearance.
I wish to convey to your lordships that the government is very keen to pursue this matter. I have applied my mind on the review judgment and to various other challenges involved in reopening this matter. But having regard to the concern of the government that we cannot abandon the victims, so the tragedy is unfolding almost every day. So I would take a little time. I would have probably placed before the court my brief note of issues, but for want of time, which I could not do. But I'm sure that we'll be able to assist the court on this very, very challenging case where more than one aspect of the matter may have to be unraveled for the first time. So I've also looked into examples elsewhere, both in case of opening settlements and also mass starts, etc. We have a considerable literature when courts have gone into beyond the settlement arena. I think I'll place all that material before the court whenever the court assembles again. But before that, I propose to share with the court my brief note of issues I thought can be gone into by the court. The Lordship may go through it through circulation, in not assembled in the court. At a later point of time, by the time we would have assembled all our materials, our convenience volumes and compilation of judgments, etc., we have a rich bibliography available on these issues. I will take a little time.
The government, you have to take a stand whether you are proceeding. You are saying you are proceeding. And but you don't want to proceed today, it appears.
Today it's only for direction. The Lordships wanted to know whether the government is keen to pursue this matter. I think yes.
How much time do you need for it? See, one, if you want, if you are proceeding with it, then you must have a separate. We don't want to take the whole record.
I understand.
A separate compilation. You must make a.
We will do that. We will
only look at the convenience compilation.
We will have a dedicated team for having that done.
From both sides. From both sides, you have to have a dedicated team to make the convenience compilation. Do your housekeeping task, and then only we listen.
I have a request,
My lords, we are.
What has happened is that, my lord, the victims, because we were there in the forefront, my lord, when the tragedy occurred, that is Bhopal Gas Pirit Mahila Udyog Sanghathan and Bhopal Gas Pirit Sangharsh Udyog Samiti. We were in the forefront, my lord. We came before this honorable court, even for distribution of food, interim leave to be given. Then we filed a review petition. It was on our review petition, my lord, the judgment came. Now, thereafter, my lord, we raised the question, even before this curative petition, that the compensation which has been given has to be increased. My lord, that SLP is pending here, which, my lord, lordships are directed to be taken up after the constitution bench decides. Now, my lord, in one case, my lord, set of victims, lordships have implemented them as parties, but we have not been implemented as a party.
We can't have this expanding notion now.
No, my lord, the question is, my lord, this. No, my lord, it will have a bearing on the fairness of the.
No.
My lord, the question. My lord,
Is your curative petition before us?
No. My lord, yes, ma'am.
Is your curative petition before us?
No, my lord, curative need not, because it is filed, my lord, parents.
We should select everybody who is affected.
No, my lord, it's like this. My lord, may I just point out?
My lords, support.
Why do you think the attorney is not capable of looking after?
No, my lord, it is like this. My lord, may I just point out? We will be committing a mistake, my lord, which we committed earlier, because, my lord, we were not heard. And then the settlement was arrived at. Now the question is, my lord, section 4 and 3 have been interpreted, my lord, in Charanlal Sahu. And what has been said is that ultimately we are necessary. My lord, the question is this, precisely. A organization which has been taken up this issue, my lord, from the beginning is not implemented. Organization.
How do you implement 100,000? You are one of.
My lord, we are there. No, we are there in the beginning, my lord. It is our petition.
My lords, on this issue, very briefly.
Our petition, my lord.
Sir, in your support. My lords, very briefly. Petitioners 2 to 6, my lords, that where we are the victims, and orders have already been passed in 2011. My lords, what they are saying, there are 7 organizations altogether that represent all the victims. There are no other organizations. So we, my lords, are for 5 organizations. The impleadment has happened. We are now parties. So my lords, what they are saying,
By which order were you made parties in this?
by 13/4/2011, my lords, they are saying, if I may just finish, then of course you
My
have your
question is
chance.
very specific.
Yes,
In
sir.
the curative petition,
My lords,
who is the party?
in the curative petition, I am a party.
Impleaded.
But it's been allowed, and then it has been said that on maintainability and merits, we will be heard.
We will not permit, I've discussed, we will not permit it like this. We are not averse to hearing a point of view. Yes. But we will not let parties be intervened like this. This creates a unmanageable situation.
My
So I
lord,
have to say something on the basis of the records and previous before us. We are not averse to listening to you. No difficulty on that account.
my lords,
But we,
very well on their point, my lords, our petition is already there as it has been said. So my lords, if that can then be, if we can be heard on the next occasion, we have, along with everybody else or whatever,
But may
we
I,
are my lords, we are already petitioners. I was only speaking up
may
with
I
their
not
support.
point?
My lords, I don't want to
No,
lose
it's not a
our
support
space.
actually, because the question is, my lord, for the victims. When we came initially, when Union of India had not filed, my lord, even the review petition, we filed the review petition. We have been, my lord,
what happened to
ultimately.
your review petition?
Yes, my lord.
What happened to your review petition?
My review petition
Partially
was,
allowed.
my lord, that was allowed. And that's how, my lord, the judgment, partially, the settlement which was there, my lord, on that
In the
settlement, my
criminal,
lord, the directions are
That
given.
is,
And one of the directions is this, my lord, and that is where, which is
Has your
important.
review petition worked itself out or not?
After review petition, my lord, we moved an application. Yes, my lord, sorry.
Has it worked itself out or not?
No, my lords, they are still
That's,
absconding.
my lord, they are
My
relying-
lord, respect criminal cases, and they are
They
still
are
proclaiming.
One second. They are relying upon, Union of India is relying upon the directions which are given in our review petition, which was filed by us.
Maybe.
And
I
one important fact, one important fact I must point out, para 197, what has been said is, where, my lord, the in curative petition, the Union of India disputes that because they say, in case UCC is not able to pay, my lord, then Union of India will pay. Now, they ultimately, my lord, dispute that the finding which is given by majority is not correct. Now, we are not on that because ultimately it will be adjudicated, but I come in because it was in my review petition, a finding which has been given is being, my lord, questioned in this curative petition. So how do I, my lord, then come in?
No, no.
Yeah, that's how I come in here.
You are satisfied with the orders passed on your review petition?
that's what.
No, my lord, they are not.
What did you do? Did you?
Yes, my lord, yes, correct. What I did was,
Did you file a curative petition?
no, my lord, what I did was curative, my lord, jurisdiction came subsequently. We filed, my lord, an IA. That IA, my lord, lordship said you go before the adjudicating authority. We went before the adjudicating authority. Then, my lord, High Court, my lord, may I just finish? High Court, and then ultimately SLP, which is pending here on the same question. After our SLP came that they filed a curative petition. That's how it has happened. So, my lord, we have been pursuing, my lord, the cause of victims from the very beginning.
Yes.
Now, I leave it to your lordships, my lord. I don't want to say anything. I just want to, my lord, I have prepared the entire thing which we did. That we should be, my lord, we should be heard because of this reason, because if you are not implemented as a party, any direction which is given, because the direction ultimately has to be binding. And they said they are on our behalf. This petition has been filed by Union of India. They have said this is parens patriae because under section 3, my lord, the right has been given under section 4. The organizations have been given, my lord, the act which was framed after, my lord, after the tragedy happened. Under 4, my lord, we have been given a right to be represented. And what this court said that we committed a mistake in not hearing the victims. Though ultimately this was a little wrong, but for a larger purpose, we are condoning it. Otherwise, it will be a violation of principles of natural justice. In a larger sense, my lord, if you are not heard, then there will be, my lord, I repeat, my lord, it is the same kind of situation which happened then will be happening now. So, lord, I leave it, my lord, victims in lordship's hands to protect us. And, my lord, team, my lord, whatever is proper order should be passed. My submission is, my lord, these are the organizations which are there. We are there from the beginning. Not, my lord, come today.
As you said.
Yeah, my lord, not come today. So if, my lord, there are certain organizations
You
which are already implemented as parties, we should be implemented as parties.
You represent 5 organizations. He represents how many?
2.
Precisely, my lord.
This is not a previous case, my lord, where the party which files a review does not come in curative. Union of India does not file the review but comes in curative. That curative is filed after 19 years of passing of the review judgment. And my lord, the criminal curative petition was dismissed by my lords because it was filed after about 17 years on account of delay. Similar curative petition on the same facts was dismissed by my lord on delay.
My lords, greatest respect. This is Union Carbide. That is absconding.
Just wait.
Contrary to my
They were right to be heard. Yes.
Lord, if I can, Lord, say. Now, Lord, in the order dated, Lord, the first aspect about the implement of these NGOs, 13th April 2011 order. The lordships have also raised the question of the maintainability of these implement applications. If your lordships will, my lords, please see that order. It's clearly said, my lord, the maintainability of the implement applications filed by the NGOs is an issue and has to be decided, my lords. Now, my lords.
Was that decided at any stage?
No. This hasn't been decided, my lords.
My lords.
Now, what happened, my lords? Since, my lords, the matter was in circulation and the notice was issued, my lord, it said that for open hearing in the court. My lord, the registry has allowed them to be implemented, my lord, as co-petitioners, my lord, though the Union of India only has filed the curative petition. My lord, curative is an extraordinary, my lord, ceremony that your lordships evolved in 2002. Well, the reason why, my lord, these NGOs cannot seek, my lords, an independent right for enhancement of the compensation, other than, my lord, Union of India subject to the merits, is, my lord, the provision of the Bhopal Gas Act, my lord, enacted by the Parliament, my lord, after the Treasury. The essence of the Lord Bhopal Gas Act is that the exclusive right has been given only to Union of India, my lords, not to the individual victims, not to the NGOs, my lords, or the organizations, but all claims in regard to the disaster, my lords, the exclusive right in regard to the damages to the person or the property or anything of the claim is with the Union of India. The constitutional validity was challenged in Charan Lal Sahu. Your lordships and a constitutional bench have upheld the act and saying that it's only the Union of India. So, my lord, NGOs today, my lords, and what is happening is applications after applications are being filed, my lords, papers after papers, documents are being done. And now your lordships have a record of more than 5,000 pages. My lord, we have also filed an application, my lord, saying that these NGOs do not have, my lord, the right of implement because of the act, also because of the order, and they should not be. This is one aspect of the matter, my lord. On the last date, my lords, when the learned solicitor, my lord, said that he would like to take instructions. The matter indeed came up for, my lord, directions, my lord, because the housekeeping has to be done, my lord, in this case. The voluminous records, compilations have to be prepared. My lords, the lordship said in the, my lord, the circulation that the councils have to indicate as to how much time. Short submissions have to be filed. Timeline has to be indicated. So, my lord, all these things have to be done. Our problem today, my lord, is this, that even yesterday night, my lord, tonight, a bunch of papers have been filed by the NGOs, my lords, which is quite unnecessary. The contest is between the Union of India, my lords, and the UCC, my lords. The lordships may, if the Union of India wishes to go ahead, my lords, we can't say anything. But he did the matter for housekeeping, my lord, give the directions, allow us. There are as many as 8 or 9 IES, substantive IES filed by them, my lord, for seeking enhancement of compensation to some, how many crores, I don't know, 20, 30,000 crores. My lords, the notice has not been issued, my lords, how do you know those applications, my lords? If they have to be heard, then we have to give response. So the lordships may decide the issue of the maintainability, my lords, whether they can be co-implemented as petitioners in the curative petition along with the Union of India. They are virtually, my lord, trying to become co-plaintiffs. That's what
I just want to add, just to add to that, my lord. First, before the NGOs come into the picture, your lordship will have to decide, my lord, whether the jurisdiction of curative was not there at the time of passing the review petition, whether the curative petition is at all maintainable, number one. Number two, Union of India did not file a review. They were satisfied with the first judgment. Now, by skipping the review, whether they can file the curative. Number three, my lord, the delay of 19 years after passing of the review judgment. 19 years, 91 was the review judgment. Union of India filed the curative in 2010. And thereafter, my lord, as I said, my lord, criminal curative has been dismissed.
And
And
one
there are
thing-
so many other, my lord, maintainability issues of the Union of India's curative petition itself. Your lordship may be pleased to decide that first before coming into the issue of the NGOs. In my respectful submission, enough material to, my lord, dismiss the curative.
One thing, just 1 minute. One thing, my lord, which I forgot.
Review
to-
was, my lord, decided in
which
open court
which
after
I-
full hearing.
which I forgot to mention is this, my lords. In 99, it was a court negotiated settlement, my lords, by a
Yes.
constitution bench.
Correct.
470 millions, my lord, US dollars, which translated into 3,000 crores, my lords. 1991, my lords, a review was entertained by a constitution bench, my lord, presided over by his lordship, my lord, Justice Venkat Chalaya. Hearing went on for 88 days, and there were only two issues, my lords. One was the adequacy of the settlement amount, $470 million, and the second, my lord, where the criminal proceedings were quashed. The constitution bench, my lord, in the review petition decided that this aspect of the adequacy of the compensation cannot be reopened. It is adequate. If there is any deficiency, my lord, in future, Union of India will meet it. However, my lord, the criminal proceeding question was reviewed, and my lord, the criminal proceedings were restored. An attempt was made in 2007, again, my lord, for enhancement of the compensation by filing IAS by the NGOs. My lord, the bench of this court, my lord, said, after obtaining the affidavit of the Union of India, we say no need for enhancement. Welfare Commissioner, who is a presiding judge, my lord, said no need of my lord, enhancement. Dismissed that, my lord, substantive IA, my lord, that there is no, the settlement amount is adequate. As a matter of fact, my lord, I must tell your lordship, out of the whole corpus of 3,000 crores, the settlement commissioner could distribute only 1,500 crores, my lord, to the eligible claimants, because there was just a law frame, my lord, for award of the compensation. 1,500 crores was in surplus. This law, my lord, this court in extraordinary jurisdiction directed that this surplus amount be also distributed on a pro rata basis to victims. So they have been paid compensation twice over, my lords, and still the amount is surplus. The latest figures in 2022 is that the amount with the RBI is still lying there, my lord, and is surplus.
They also, they have both rupee amounts which are left
And dollar amount.
Dollar amounts. I'm not, the issue will really be to supplement what my friends have said. Your lordship, when you frame the rules, say very specifically in the rules in chapter 47, you say that a curative petition shall be accompanied by a certificate to the effect that it is the first curative petition. So now the first curative petition, whatever its merit has been filed, we will have to argue it in our own turn on its maintainability. In effect, without filing a curative, the NGOs who lost out in the judgment reported, as my learned friend says in 2007, volume 9, SCC 707, now seek to ride on the wings of the union and come through a back door and then agitate their claims. Now that can't be done. And please see the order of 2011. There is, I'm sorry to say, it is an incorrect statement to make that their applications for impingement were allowed. A revised order came to be passed on the same day. The revised order made it very clear that maintainability has to be considered in those matters. And that revised order is part of the record. My learned friends cannot say they were impeded. That's not correct. So the registry has inadvertently done so.
My lords, if I may briefly
Please see the revised order.
respond to this point, beginning with the order, I'll read it out, my lord.
Read the
It
revised.
says, I didn't interrupt, sorry, if I may have just a couple of minutes. Interlocutory application numbers 7 to 9, these are mine, are allowed subject to service. Subsequent to that, it says, issue notice on the maintainability of the interlocutory applications and merits of the matter.
Because
So, my lords, the hearing that happened then, and in fact, in a lighter note, the Chief Justice was representing us in the criminal curative petition. Our interlocutory applications were allowed. And what was said was that subject to maintainability and merits of the matter. Because it was recognized, my lords, that these are inextricable. My lords, we had filed an application for impediment pursuant to the right given in Charan Lal Sahu, which is a 5-judge bench. they had looked at the Bhopal Gas Claims Act, Section 4, and they had said that, look, we can't make up for the fact. I mean, we can't unravel the settlement to the extent that you weren't heard prior. So now that's all done as water under the bridge. But now you must be heard. And what it says, and I quote, in order to make the opportunity contemplated by Section 4 of the Act meaningful and effective, it should be so read that the victims have to be given an opportunity of making their representation before the court comes to any conclusion. In addition, Section 4 says, the central government shall have due regard to any matters which such person may be required to be urged. Now that the learned Attorney General has made such a heartening statement, we are deeply hopeful that they will have due regard to our pleadings as petitioners 2 to 6. But my lords, regardless, we have our claims before the court. My lords, there are two aspects of the review, as one of my friends very fairly pointed out. They said that, and this might narrow the issues a little bit, they said that there is the civil aspect, which is the $470 million, and then there is the criminal aspect, which was initially quashed. And then their counsel invited the jurisdiction of this court explicitly under Article 142, citing the Sancheta set of judgments, in order to say, please support, please continue the withdrawal/washing of the cases. This court considered that issue and said, no, we are not doing this on the basis of a public policy. We are saying because in this case, the matter must be investigated. Not in any regard did they say that this is without prejudice to the argument that they are not submitting to the jurisdiction of their court. And yet, the next day, Union Carbide said through their counsel, I have these documents on record. Union Carbide said that through their counsel that this court has no jurisdiction over us with regard to the criminal cases. 4 months later, and we have that on record, the criminal court concerned, the jurisdictional criminal court, declared them a proclaimed offender under Section 82. To this day, they are absconding. It is recorded in the final judgment against UCIL. And so with regard to the second part, my lords, there's no more delicate way to put it. We believe that they have played a fraud on the court. There was an order that was placed after that with regard to attachment, my lords, of their properties. What they did, and these are not my words, these are the words of a district court in Connecticut, a federal judge in Connecticut, their country, said that the admitted facts are that after the Bhopal gas disaster, they set up a web of intermediaries in order to bring their goods into the country. My lords, with regard to the settlement itself in 2009 and 10, through the process of RTI, but also the US discovery process, which is quite rigorous, and they're on pain of criminal penalties, documents can't be suppressed, etc. Documents were discovered showing that they had an internal report which says that methyl isocyanate, once inhaled, only causes permanent injury if you have been in it for, say, a few hours. They had proposed, and this is the basis of the settlement is a top secret document. And I quote, it says top secret right on top. With the government at the time, which proposed categories of temporary injury and permanent injury, and over 98% of the claimants have got under temporary injury on average of 25,000 rupees, whereas they knew that the injury is most likely in all cases to be permanent, and that was suppressed. How are we arguing suppression? And this all we will place, my lords. We are saying that they suppressed it on the basis that they told the the Environmental Protection Agency that this is a trade secret. We are required by law to give you these documents. Please do not disclose them further. But the Environmental Protection Agency decided otherwise. So, my lords, a recent 22 judgment, but all the way down from Chengalwade, as my lords are aware, God must unravel a judgment. Cannot sustain. And my lords will explain that 2004, not 2002, 2004, the curative jurisdiction arose and why we are coming in 2010.
And I'll take only 2 minutes. I'll not take minute because I already said minute. Number one is not saying NGOs may not be correct because we are representing the victims not from the very beginning. And our locus has been accepted by virtue of the fact that it is or it was on our review petition, my lord, that the Constitution Bench gave the judgment, wherein, my lord, they considered even Chandralal Sahu interpreting, my lord, the provisions of the Act. Now, while interpreting the provisions of the Act under Section 4, 3 says that Union of India will file on behalf, but 4 is an exception to it. 4 says that the victims will be heard through their counsel, etc. They have a right to be heard, my lord, whenever the settlement, etc. Because now the settlement is being reopened. Therefore, it is necessary, my lord, by virtue of the enactment and the 2 judgments which have been given, that the persons who are there, I'm not talking, my lord, we are not people who have come just like that, my lord, we are there from the beginning. I have prepared the dates, my lord, and all the proceedings in which we intervene, as far as we are concerned, my lord, from the very beginning. So, my lord, I am not going to the merits part of it. I am saying, my lord, it is necessary that we should be implemented and heard in the interest of justice, so that, my lord, it will not be that the victims are not heard, the settlement took place, and at this juncture, when it is very, very necessary, the victims, my lord, because we will be able to assist this honorable court, my lord, to a very great extent in arriving at, my lord, the just kind of disposal of the matter.
But may I
May I only one thing, we have.
See, what is happening is, Mr. Jha,
It's
you argue in the beginning, you argue in the end, then you argue something. This can't go on like this. This is exactly what we will not permit in the proceedings which will take place.
Yes. I was finishing it.
You have to have a disciplined proceedings. It can't be like this that today we have a little time. So you're going here, there, somebody's coming in, somebody's going out. It can't go like this. No.
But the last thing is that the specially petition which we filed, I just pass on the order. That may also be tagged with this thing.
We are not here to tag. We are hearing a curative
May
petition.
I do not the order which was passed in the TP, which was a connected matter, where implement was declined, or and may I just pass the order that's listed? Please, can you pass it?
May only have a few minutes of your lordship.
You will have the last say. You had the first say, you will have the last.
I know, I also want to gather all the thoughts.
But this is an order, but there is a petition pending in the High Court. The union has filed a transfer petition to get the writ petition brought here. This is an order in the transfer petition, which is connected to this batch of matters. It's the last in today's slot. And kindly note, heard learned counsel for the applicants and learned senior counsel for respondents. Applicants Bhopal Group for Information and Action will be heard before any orders are passed in TP, but will not be added as a respondent. That is the order passed in the connected matter. That TP is also listed in today's cause slot. That's 502. 502 lot.
We have no objection.
Item 502 lot.
No. You have had your say.
But so what I'm saying, today the fact is twofold. On the one hand, no curative by them. On the other hand, the rules say the first thing.
I've understood.
That's all. I'm not going to repeat.
Yes, certainly.
No, I didn't. It's entirely the discretion of the court as to who shall be heard. But today, after several stages, the initial stage, of course, everybody had a right to be heard. There were several concerns, several ways of, presenting perspectives on this matter. And speaking for myself, we're all gone through this. I had an opportunity of assisting Professor Bakshi in the early stages of litigation. We have gone through representing victims on the one side and also government on the other side. I have fairly a good view of the unfolding dimensions of the case. So at the early stage, everybody heard. I don't want to be heard today saying stifling, but it's right to be heard. I don't like that. Stage where the only question for the parents of Patra concern is either adequacy of compensation to be revisited. If on that question, if last thing everybody need to go, it is an entirely different matter. But if it's a matter entirely between the court and the Union of India and what parameters we can reopen it, and then how, and then what parameters the adequacy of the compensation can be revisited, is a matter I thought is where the Union of India may have to assist the court in a large measure.
See, they have flagged 2 issues. One, the fact that you never filed a review petition and you came in a curative petition after 19 years. What is the ramification? You have to examine. They have never filed a curative petition, filed a review petition which was disposed of.
Sure.
Correct. Now, what is the capacity in which they are to be heard? These are two, apart from any other issue, this will be issues which will arise. As a pressure. Parties. Learning Attorney General has taken a stand before us that the government would like to press its security petition. Good stuff. A number of NGOs seek to be added as parties before us. Correct. Good stuff. On the other hand, the respondents say that very maintainability of the curative petition would have to be examined as it comes 19 years after the judgment was passed and without going through a process of a review application. Good stuff. The persons who filed the review applications on which orders were passed have not filed a curative petition. And the conspectus of the was that we issue the following directions. First, the government would represent the claim of the person who have suffered, and thus a compilation would be required to be prepared by the Office of the Attorney General and the respondents, which would be the compilation alone to be referred by us in the proceedings. Number two, insofar as the applicants' associations are concerned, we do not give any liberty to file any pleadings, but at the relevant stage, we will see to what extent assistance can be given by the councils, and we do not foreclose their right to be heard by us at our discretion. Next, the joint compilation, we prepare it within, how much time will both of you prepare it? It will take about 6
we need at least about 4 to 6 weeks to prepare the company. So the additional material may have to be scanned and then
No, whatever.
properly.
There's one. You say now, see, attorney, you know.
I quite see that.
Follow
We
on
don't.
6 weeks is 7 into 6, 42 days. So let's be clear on the days. So you wanted now 6 weeks, whatever. Not difficult.
8 weeks.
Not so we are not.
8 weeks.
But 8 weeks will mean 7, 8 is 56.
Yes.
Yes.
Right, within 8 weeks as grade 4 in brackets 56 days. That is close. Timeline has to be adhered to.
Absolutely.
Not broke any deviation.
No compromises on that.
Now, thereafter, you will also have to file your
Submission.
synopsis or submissions.
Yes.
The parties will also file a brief synopsis. How many pages each?
5 pages.
For me, maybe a little
Each will
more.
be longer than that, make it 10.
More.
10 pages.
See, we have to learn to.
No, I know,
To
but-
time limits, we have to learn to adhere to pages.
Uh,
Otherwise, it becomes an indefinite cumbersome process.
My lords, if
Let-
I may
let-
have a
You
last.
can't interrupt in between, sorry.
10 pages.
10 pages would be
Number of
sufficient.
dates.
No, dates are different, submissions are different.
Not keeping in view the number of facts, not then they may take 10 pages. Within 10 pages.
In 10 pages as per.
I know.
Very.
We will keep it once for housekeeping so that we are sure that everything is ready, then only we'll list it.
Sure, Lord.
Otherwise, we don't want to put a time for listing, so we'll assemble to see whether you have done what is required to be done.
Correct. Absolutely.
So 8 weeks, synopsis will be simultaneously filed, or how do you want it?
No, we may file it a little thereafter, after the compilation gets ready, because we may have to do some.
Within 2 weeks thereafter?
Yes.
Within 2 weeks.
We may also need to file some additional documents, materials as part of a compilation.
No. Can't be
No,
like-
to,
We are not having a fresh petition to be.
no. To
There has to
present
be
the,
nuances of curative in it.
No, certainly, I understand the limitation to the curative hearing, but then to update what is the current data and analysis of this. So we need to apprise your lordships of what is the current position. It's very important side of
Within
making.
2 weeks thereafter.
Yeah.
That's it. Learned attorney says that with the compilation. I thought you will file a joint compilation.
Yes,
What I wanted you.
But we nominate one of our colleagues who will sit with the attorney's colleague
Then
and make a joint
it
compilation.
says that some documents may be permitted to be filed on record, limited to the updated position at the ground level. Nothing more than that.
My lords, may I have my lords very, very brief indulgence on the
What
implications?
after the order is passed?
My lords,
We heard everybody at leisure.
my lords, this
Yes, sir.
point has not.
After having done so, sometimes some order goes in favor of somebody, sometimes it's a more restricted order. Having passed that, you have to accept it. There's no persuasion on that.
My lords, my lords,
We've given you a halfway house. We are quite conscious of it, but that's what you get.
my lords, just on this claim, they are only asking for a refund, the union. So the anguish of the Bhopal victims will not be alleviated, my lords. Our
Sorry.
claim is different, which is
Sorry.
why the order was
Sorry.
passed in our favor
Sorry.
in 2011, my lords.
No, we will
I
not.
am not saying anything about the order, my lord. I am only requesting whether we can put, my lord, in 2 pages our
No.
points.
No. We will hear you on the. Be rest assured, when we give you a hearing, we will.
I know, my lord, Lordships have said.
You can argue on the basis of what is filed by the AG's office.
Yes.
So you can collect it from the AG's office. There is no difficulty.
Of course, our office is always open very.
My lords, this will put us in grave difficulty, but we hope that the union will have due regard under the act to our claims, because they are just asking for a refund, right?
नहीं बनता नहीं, 9 weeks की आती है। 10 weeks vacation में चला जाए। Settle तो हो गया था।
So 2nd January it will reopen. 2nd would be a Monday.
Second में बोल रहा है आपके पास? पिछला साल का।
नहीं पिछले बार मुझे डेट देखा ना 31st is Saturday.
Saturday.
1st is Sunday. 1st January is Sunday.
This week वैसे miscellaneous तो है।
2nd week में 2nd and 9, 10, 11 को लगा सकते हैं। 10th को लगा दी Tuesday. No, no, Monica.
10th January at 10:38.
Lord, I didn't just contact, that may be miscellaneous.
No, no, that's the second week we are
Second
coming.
week.
10 January.
10 January.
10th January.
Yeah.
Right.
So we took care of the admission week.
Very great.
So, my lord, if you probably in our anxiety had something not more than, but then it was, my lord, because naturally for such a long time, yes. That's.
A lot of anxiety with the
Now it's over. The